We will now start India-Japan Trade Relations Risk Mitigation and Dispute Resolution Symposium。これより、日印貿易関係リスク軽減と紛争解決シンポジウムを開始させていただきます。First, I would like to request His Excellency, Mr. Shibi George, Ambassador of India to Japan, to make opening remarks. はじめに、駐日インド大使、シビジョージ閣下より開会挨拶をいただきます。
Good afternoon, everybody. Distinguished speakers, ladies and gentlemen, once again, good afternoon and welcome to Embassy of India. I'm delighted to address you today at the Symposium on India-Japan Trade Relations, Risk Mitigation and Disputes. Friends, India and Japan have a special strategic and global partnership rooted in shared values, mutual respect, and a common vision for a peaceful and prosperous future. Over the years, this partnership has grown exponentially. India and Japan have become indispensable partners in promoting peace, stability, security, and prosperity, not only in the Indo-Pacific region, but also beyond. Today, our relationship covers a wide range of areas: trade and investment, industrial development, infrastructure, rail, metros, digital, energy, human resources, critical and emerging technology, climate change, health security, space, semiconductors, defense and security. A key aspect of our bilateral relationship is our economic cooperation. Japan, being the fifth largest investor in India, has been a reliable partner in India's economic growth. The prime ministers of our two countries have set a target of 5 trillion yen in private investment and public financing from Japan to India over the next 4 years. And we are making remarkable progress towards achieving this goal. Today, we have 1,500 Japanese companies in India, 1,500 success stories. We need to tell these success stories to other Japanese companies here. My target is to make it from 1,500 to 15,000 Japanese companies to be partners in India's growth story, and I am sure that we can achieve that. What we need is not an incremental progress. What we need is a quantum leap. It is important to recognize that there is substantial untapped potential in our business engagement. India, with a population of 1.4 billion people, representing 1/6 of the world's population, is one of the world's fastest growing economies in the world. It has been consistently improving its business environment with progressive policy reforms, increased ease of doing business, and improved infrastructure. Japanese companies can immensely benefit from the cost-effective labor, vast market access, and strategic geographical location that these industrial towns offer in India. It is my 9th month in Japan, and I have had the privilege to travel all across this beautiful country. Actually, I visited 32 prefectures, and each of these prefectures where I met with the business community, I came back with the satisfaction to see that there is a momentum for India in Japan. These interactions have revealed a momentum and overwhelming enthusiasm and a spirit of partnership towards building business relationship with India. Our aim is to convert this momentum into tangible outcomes. To support this, we have taken the new initiative at the embassy, including by setting up an SME facilitation cell to encourage more Japanese SMEs to work with India. Dear friends, one of the key challenges faced in international trade is the mitigation of risks and resolution of disputes. Effective risk mitigation and dispute resolution mechanisms provide a sense of security to businesses looking to invest in either country, reassure investors that their investments will be protected, and that they will have recourse in case of disputes, thus making the countries more attractive investment destinations and fostering long-term trade relationship. This symposium is a step towards strengthening India-Japan trade relationship by addressing risk mitigation and dispute resolution mechanisms, which serves as a platform for exchanging ideas and developing strategies to enhance the resilience of our trade ties. Dear friends, I thank you all for your presence today. We renew our continued support and cooperation to Japanese companies in their efforts to establish their businesses and investment in India. Let me tell you this, not a single day in my stay in Japan goes without interacting with at least a few Japanese companies who are ready to expand their presence in India. And we are here to work with each one of you. We are always available. My commerce team is available. Please be in touch with us to follow up on the discussions you have here today. Once again, I thank you for uh, organizing this symposium here. Thank you and good afternoon.
Thank you, sir. Next, I would like to request Ms. Niti Sachdeva, Secretary General, Mumbai Center for International Arbitration, to give a remarks. 続きまして、ムンバイ国際仲裁センター事務局長、ニーティ・サチテーバ様よりご挨拶をいただきます。
Thank you very much, Honorable Ambassador Shri George. Speakers, friends, ladies and gentlemen. It's actually an honor and a privilege to be standing here and to be amongst all of you. And for me, it's even more special because for the ones who are not aware, MCIA started its first international symposium from very much here in Japan in 2018. And that was just 2 years when MCI was established, and there were a lot of questions asked that a new institution, what are you trying to do in Japan? And of all the places, why Japan? And I think at that time we set the tone by saying that India and Japan have a growing trade relations. And for any trading partner, it's not only important that you provide a safe haven to do your work, but you also need to provide a very efficient, effective dispute resolution mechanism. And I think MCIA has that agenda to say that if you have any India-Japan business, it's rather unfortunate that we do see ourselves in dispute at times, but that should not be a reason where the business should suffer. It should continue, and MCIA or the Japanese arbitral institution should be able to provide you a safe way to effectively and efficiently resolve your dispute. We come here to Japan to bring to you this, have the support of the Japanese law firm, Japanese business houses, and in India to clearly say that we are not here to say that please come and litigate, arbitrate in Japan, in India. But the idea is that whenever you're doing a negotiation, we don't see a reason as to why an Indian party or a Japanese party should be thinking outside of these two countries to resolve their dispute. I think I'll be failing in my duty if, as the representative of MCIA, I do not say a few words about what MCIA is and what you should expect to hear from us, and of course to our two panels with great speakers lined up. MCIA was established in 2017. We are the first international arbitral institution in India. We take great pride to see that we are not only neutral and independent, because we are the only arbitral institution in India which is neither managed or run by the government, by any courts, or by any chamber of commerce. So we are truly independent in that sense of having to say that you can very clearly resolve your disputes with MCIA without any intervening factors of that sort. When we, of course, started MCIA, one big question was this, that India still prefers to have ad hoc arbitration. So what is it that MCIA is trying to do? And I'm very happy to tell you that we were actually the first arbitral institution where the Supreme Court of India, which is the highest court of our country, actually referred a matter and said that we are not the ones who are appointing the arbitrator. We will delegate it to MCIA to do it. And that was just not one off the case. Since then, every year we've been getting matters from the Supreme Court, from the high courts, not only to appoint arbitrators, but also to administer the disputes. We take our responsibility of appointment of arbitrators very seriously because, as they say, that your arbitration process is as good as your arbitrators. And MCIA has been leading its efforts in two directions. One is diversity and one is ESG. When I say diversity, we walk the talk. Last year, we had 33% of our appointment as women arbitrator. 60% of our arbitrators were the first time arbitrator appointed. And of course, the Secretariat helps them in going by the easy steps of whatever help they need in making the process more efficient. When I say ESG, you won't really find any MCIA material outside to be taking back on the rules because we take very seriously what our Prime Minister's motive also is to say that India will be ESG aligned by 2050. We are trying to do our bit. So anything that you need to know about MCI is all available on the website, and I am here in person to answer any questions that you may have. With that, I would like to thank you all to be here this afternoon, rather on a short notice. I was told when we were planning this that, Niti, this is not how Japan works. You need to plan things 6 months in advance, invite people on time. You can't be expecting people to be here on a 2 weeks notice. I feel bad that I should have respected your culture, prepared it well in advance, and I promise you that next year you will see a much better role from our side. But thank you to all of you to having spared your time on such a short notice. Thank you very much.
Thank you, ma'am, for the remarks. Next, we will move on to the panel discussion. Panelists for session 1 may kindly come at the stage. ここからはパネルディスカッションに移りたいと思います。パネリストの皆様は壇上へお上がりくださいませ。In this session, I would like to request Ms. Taeko Suzuki, partner Nishimura and Asahi, to moderate this session. ここからは西村朝日法律事務所パートナー鈴木妙子様に進行をお願いしたいと思います。
Thank you very much. Okay, thank you. So welcome everyone. We're starting the first panel with esteemed panelists, my co-panelists. So let us start with a quick self-introduction. My name is Taeko Suzuki. I'm very honored to be the moderator today. And I head the India desk at Nishimura Asahi, and I've been working on the India-Japan business corridor for over a decade. I spent 2 years in India, and now I'm based in Tokyo, mostly advising Japanese corporations on India investment. Right now, I've been super busy on India M&A or joint venture and corporate work, but half my work is also on dispute side and advise Japanese corporations how to manage disputes in India. Over to Kotoura Sensei. Can you, switch the slides to the next page? Sorry, someone on, yeah, next page, please. Next one is on Kotoura Sensei. Ryo Sensei, please.
Hi, good afternoon, everyone. I'm Ryo Kotoura, a partner of Anders Mori and Tomotsune, a Japanese law firm. I have experience of working at Mumbai, India in 2007. And since then, fortunately, I have a lot of matters in which Japanese companies are making investment in India. And I supported many Japanese companies to make investment in India. As Ms. Suzuki mentioned, unfortunately, there are a lot of disputes along with increasing number of transactions between Japanese companies and Indian companies. So I'm doing a lot of dispute resolution works as well as investment and M&A works. And I'm registered as an arbitrator at MCIA, who is the moderator of this panel discussion. Thank you.
Thank you. Next page, please. So Daniel Sensei.
Hello, everyone. My name is Daniel Allen. I'm a partner at Mori Hamada and Matsumoto, also a big firm here in Japan. You can see most of the details on the slide, but I'll say a few things about myself anyway. My area of practice is international arbitration exclusively. I act as lead counsel on arbitration matters. I haven't yet had one at the MCIA, but I'm looking forward to it. I don't think anyone else is, but I'm looking forward to it. Yeah, I've worked on a lot of big Indian disputes, particularly joint venture disputes. A lot of Japanese joint ventures. I'm sure we will talk a lot about joint ventures throughout the course of this these two panels, and that is where most of my experience with India disputes lies.
Thank you. And last but not least, next page, please. Karan, over to you.
Thank you very much, and thank you to the Embassy and Excellency for hosting us today. My name is Karan Chindeok. I am a partner with Chindeok and Mahajan. We're a law firm based in India with 4 offices across the breadth of the country. I'm a competition and regulatory lawyer, but I also do arbitrations and civil disputes as part of my day-to-day job. But as a word of, after spending many years with Alan Overy in London, I moved back to India, and this is the startup culture in India, right? So we decided to start our own law firm, and the economic success of India has a direct relationship to the economic success of law firms. And that is why we are here today, and pleasure to be here. So thank you.
Thank you. So before jumping on to our topic, today's topic is arbitration, but I think we have Karan. So maybe you can start with what's the hot legal topic in India and what's to look out for.
Well, I think I'll be doing disservice to this panel if I don't say arbitration and dispute resolution is a hot legal topic, and it will always remain so. I think there is a focus, as the master put it very rightly, that there is investment, but also there has to be enforcement and protection of investment, and that's very important. And to that, but also what is equally important is preservation of the relationship. And the Indian government has very recently notified a new mediation law, which has recently received the assent of the President of India, and that is focused on getting disputes settled by way of mediation, so that parties are able to not only move on, but also be able to preserve that relationship, which is very much part of, I believe, both cultures, both Indian and Japanese. As far as the other interesting topics are concerned is, I think we also have a new data protection law, which is the Digital Data Protection Act. That looks to predominantly at data, which actually only looks at data which is stored in a digital form. So if you have something on paper or anything else, the act has no applicability. The law is going to be operationalized through regulations, and that is going to have on how data is processed, how data can be exported, how consent works, and so on and so forth. And that is going to be important for any company operating in India, or having any data of Indian citizens. We hear the Honorable Minister has just recently said in the next 30 days or so, we're going to have draft regulations in place, and those are going to be important from a stakeholder's perspective to have an active engagement, and I would always encourage everyone to participate in that collaborative process. The other important aspect which is taking place in India, and just as a more from an enforcement perspective of, we have multiple regulators. We see a lot more focus in India by supervisory bodies and enforcement agencies such as the Enforcement Directorate, the Central Bureau of Investigation, to weed out fraud and to make out a country which rule of law is upheld. And to that end, we are seeing a lot more scrutiny by investigation agencies on businesses to ensure that there is a culture of compliance as far as operating in India is concerned. The other important aspect, what we also see as part of that culture of compliance, is competition law. There have been some sweeping changes that have come into place in April of this year. They are going to bring in a new regime. In fact, always when I look at my own clients, I think a large majority of them are based in the US, but the other half is actually all Japanese, because the culture of compliance with Japanese companies, not only in their own jurisdiction, but also elsewhere, is very high, coming from after years of sort of antitrust scrutiny in Japan and elsewhere. In India, we are seeing new changes to merger control when certain transactions will require approval from the Competition Commission. There will also be a new settlements and commitments regime where parties can settle with the Commission and be able to engage without intrusion into their business models. And the last but not the least, there will be a new leniency plus regime, which allows for parties to come forward in case there is any collusion and they want to take immunity from the Competition Commission of India. So that's very broadly the new regulatory landscape in India. Thank you.
Thank you. I just quickly summarize in Japanese for the audience. 今、カランさんからは、最近の特に大きな法改正としまして、今年の8月の国会で調停法がまず通りました。またその後にデジタル個人情報というのがいよいよインドでも通過したということになります。また外国投資の促進という観点からは、ガバナンス、それからコンプライアンス重視の法令がそれぞれ通りまして、特にインドにおける不正防止に関するシステム、それから競争法に関しても今般数多くの法改正が制定されています。ちょっと細かいところはまた彼、特に競争法の専門ですので、別途終了後にぜひ質問いただければと思います。Okay, so let's move on to our main topic today. Can you move on to the next slide, please? So one of the critical parts when we are negotiating a deal with India-Japan investment, one of the critical one will be on arbitration agreement. We seek to choose what forum to choose, what institutions to choose. So Kotoura Sensei, could you give us an overview and what you generally advise to your clients?
Okay, thank you very much, Suzuki Sensei. You may know that arbitration is frequently chosen as a dispute resolution method in the commercial agreement. The process of arbitration compared to litigation is that it can be completed by one instance, or the enforcement of arbitration is ensured by the New York Convention, blah, blah, blah. So some of you know very well the advantage of arbitration. But when you wish to refer a matter to arbitration, you need to have an arbitration agreement. So it means that the parties have to agree that the matter will be referred to arbitration for dispute resolution mechanism. And as Suzuki said, I'll talk in Japanese language. 仲裁は訴訟と比べて、例えば1回で解決、1回的解決が図れるとか、あるいはその執行がニューヨーク条約によって担保されているといういくつかのメリットがあり、紛争解決方法としては頻繁に選ばれる方法になってきています。ただ、訴訟と違って、紛争を仲裁で解決しようとする場合、仲裁合意というものがないとできません。当事者間に合意がないのに、この紛争を仲裁で解決しましょうと言っても、仲裁で紛争を解決することはできません。Okay, so now, sorry, moving to next one. But as you know well, people cannot reach an agreement for dispute resolution method after they are in the dispute. It means that if you wish to reach an agreement for the dispute resolution method, you have to do it before dispute happens. And it means that you need to agree the arbitration clause in the some trade agreements or transaction agreements or some other commercial agreements. Let me speak in Japanese. 仲裁で案件、紛争解決するためには、先ほど申し上げた通り、仲裁合意というものが必要なんですけれども、紛争になった後に仲裁で物事を解決しましょうと言っても、なかなかうまくいかない。もうすでに紛争になってますから、どうやって解決するかというところからして合意ができない可能性が大いにある。ですので、実務上は、最初の契約、それは取引契約かもしれませんし、株式譲渡とかの契約かもしれませんし、その他の契約かもしれませんけれども、その契約の中に仲裁条項、仲裁規定ということを入れることで、紛争が起きたときに仲裁で 解決しましょうということを合意します。I have experience of more than 15 years for the Japan and India transactions. And as far as I observe, 80% or 90% of arbitration clause between the Japanese companies and Indian companies agreed to be referred to SIAC, Singapore International Arbitration Court. And the rest of 10% or 20% are referred to the arbitration in India, or very hardly we observe that the arbitration is referred to JCA, Japan Commercial Arbitration Association. And this is not because the arbitration in India that could be an arbitration under the Arbitration and Conciliation Act or arbitration at MSCIA is not reliable or not trustworthy, but because the parties are Japanese companies and Indian companies. As you know, when two parties agree a dispute resolution method, they usually prefer a third country. They do not prefer the home country of the other party. So if Japanese companies and Indian companies agree the arbitration in India, it means that from the perspective of Japanese companies, it means that you have to initiate the arbitration in the home country of the counterparty. That's the same thing can be said for the Indian companies. So because of this, Indian companies do not prefer to refer our case to our JCAA, the home country of Japanese company. 私が過去に15年ぐらいいろいろインド企業と日本企業の契約を見てまいりましたけれども、仲裁が合意される場合の8、9割方はシンガポールでの仲裁というのが合意されています。で、その理由はインドの仲裁が信用できないとかですね、インドの MCI が信用できないとかそういうことではなくて、単純に相手のホームカントリーで紛争解決するということを、お互いに好まない。日本側はインド企業との契約においてインドが紛争解決になるということを好まない。逆もまたしかりで、インド企業側は日本で紛争が解決されるを好まないということで、第三国であるところのシンガポールが選ばれる傾向が強いということです。But recently there was some new trend. So Indian lawyers may know that the Supreme Court of India admitted the enforcement of emergency arbitration at SIAC. The place of arbitration was in India, not in Singapore, but the Supreme Court of India granted an order in which emergency arbitration granted by SIAC can be enforced in India. And this is a very critical impact on the practice because when we agree the arbitration clause between Japanese companies and Indian companies, one issue always comes up. That is, if we should exclude Section 9, applicability of Section 9 of Arbitration and Conciliation Act, it means that if we exclude the possibility of interim relief in India or not. 先ほど申し上げた通り、日本とインドの紛争だと、やはりそのインドが選ばれるということはなかなかなかった、今もあんまりないんですけども、ただ、この動きに一つ最近新しい動きが出てきてまして、それが、インドの最高裁判所が、シンガポールインターナショナルアービトレーションの、がインド国内で下した緊急仲裁案件について、インド国内での執行を認めたということがあります。で、これがなぜ重要なのかというと、日本企業とインド企業が仲裁を合意する場合には、インド国内でのインテリムレリーフ、これ日本風に言うと仮処分ですね。仮処分の提起可能性を排除するかどうかということが常に議論になります。Okay, the reason why the applicability of Section 9 is always comes up is that even if you agree the arbitration at Singapore or some third-party country, if Indian company or Japanese company can initiate the interim relief in India, I observe that in most cases, Indian companies initiate the interim relief in India. Japanese companies have no other choice but to dispute it in India at the Indian court, because also it is called as interim, but still it has a definitive power until the final order of arbitral tribunal is granted. And as you were aware, the court proceeding in India often prolong, and it sometimes takes, say, 4 years or 5 years, even in the case of interim relief or some other cases. So I observed that our Indian counterparty tries to prolong the processes once they got the interim relief within the initial 10 days. And after that, it took more than 2 years, although it was interim relief. なぜこのインテリムレリーフを排除するかどうかというのが議論になるかというと、せっかくシンガポールでの仲裁とかを合意しても、インド国内で仮処分を提起されてしまうと、これは応訴せざるを得ないという問題があります。これ、応訴しないと、インド国内で仮処分が有効になってしまって、それに従わなければいけないという問題が生じてしまうと。なので、このセクション9を排除するかどうか、これはインド国内での仮処分を認めるかどうかというのが、かなり大きな問題になると。However, if the parties agree the exclusion of Section 9, it means that even if a Japanese party or Indian party wishes to have some interim relief or emergency relief, they cannot refer it to the Indian court. And in such a case, now we can refer it to the emergency arbitration at the arbitrary tribunal. But one important thing is that the Supreme Court of India did not allow enforcement of emergency arbitration granted in Singapore. So it was granted in India. So in order to ensure that interim relief or emergency arbitration is enforced in India, you have to choose the institution which will be, the arbitration place is in India. 仮処分、インテリムリリーフがインド国内で起こせない、それを合意することで、インテリムリリーフはインド国内でできないということになるんですけれども、今度その合意をしたら別の問題が出てきて、相手の行動をとにかく今すぐ止めたい、仮処分的に止めたいといったときに、今度はインドの裁判所に行けなくなるという問題が生じてしまいます。で、この時に使えるのが、仲裁におけるエマージェンシーアービトレーションで、これは仲裁版の仮処分みたいなものですね。これができる。ただ、インドの最高裁は、インド国内で認められたエマージェンシーアービトレーションについては執行を認めたんですけども、インド国外で認められたエマージェンシーアービトレーションについては執行を認めたわけではないと。なので、仮処分をしたいという欲求がもしあり得る場合には、インド国内で仲裁をしないといけないという問題があります。So when the parties wish to exclude the Section 9, I mean the involvement of Indian courts, but reserve the right of interim relief or emergency arbitration, they should choose arbitration place in India so that they can file an emergency arbitration. And in such a case, I observed that SIAC in India granted the emergency arbitration and the Supreme Court has allowed to enforce it. But I do believe that the emergency arbitration at MCIA must be also permitted by the Supreme Court of India to enforce it in India. So now, because of this emergency arbitration issue, the MCIA could be a very important option for Japanese company, which does not want involve Indian courts, but wishes to reserve the right of interim relief or emergency arbitration. 先ほどお話しした通り、 インテムリリーフを排除してしまうと仮処分というものができなくな仮処分の申し立てというのはできなくなってしまうんですが、エマージェンシーアビトレーションができれば、その仮処分に変わるような効果を得られると。ただ、インドの最高裁はですね、インド国内で下されたエマージェンシーアビトレーションについては、仮処分と同じような執行を認めたんですけれども、日本国内で、すみません、シンガポールで下されたエマージェンシーアビトレーションについては、まだ執行を認めていないと。なので、日本企業にとっては、仮処分的なことができないのは怖いと。それは全くできないのは怖いと。ただ、一方で、インドの裁判所で裁判もしたくないということであれば、あえてインド国内を、仲裁地に選んだ上で、何かもし仮処分的なことをしたい場合には、MCIA、あるいはシアックもインド国内での仲裁地として選べますけれども、そこでエマージェンシーアビトレーションを申し立てるという方法が近時有力になってきております。Okay. That's all from me. Thank you very much.
Thank you, Kotora Sensei. I think one big takeaway from his comment is that, as you see, India arbitration space is very much evolving, and it's changing, I should say, every single day, unlike it is in Japan. So we need to revisit our arbitration clause as and when. So Amazon case is just 2 years ago, was it? Only 2 years ago, and the arbitration space and how we draft up the arbitration clause completely changed.
I agree with you. So the development is very, very rapid. So we have to review the arbitration clause on a monthly basis so that we can follow up all the cases, our precedents in India.
ありがとうございます。今も琴浦先生のお話からも最高裁判決という話がありましたが、インドの最高裁判決しょっちゅう出まして、それによって大きく我々のアドバイスの方針も変わってくるというところがやはりインドと日本の大きな違いかなというように思います。So let me allow me to share some of my experience on ad hoc arbitration and also institutional arbitration seated in India. And Karan, let me ask you if you agree with my comment after. So I've advised on one ad hoc arbitration seated in India, and also another one institutional arbitration. But at least they say it's institutional. But both of them, unfortunately, not a pleasant experience because due to the delay. For example, ad hoc arbitration I have worked on, it took more than 3.5 years to just close. To get the award because the arbitrator was an ex-judge, and unfortunately no one was managing and no one could force the arbitrator to get the earliest hearing dates. So it just went on and took 3.5 years. Another one was institutional, but unfortunately that institution never really managed. I've never seen the administrator, so no one set out the timeline. So it also went on for more than 3 years. So, but however, now that MCIA is quite active in India, I've been advising some of the clients, especially when I advise a Japanese subsidiary in India, who's regularly having, for example, supply agreements with the Indian counterparty. In that case, maybe the amount at stake in case of dispute is relatively small, then I comfortably do advise that please go for an institutional arbitration agreement, and please choose MCIA rather than some other institution that I don't know of. So, Karan, could you also share with us?
Absolutely, I couldn't agree with you more. I think the longest arbitration. So, sorry, let me dial back in time. I think the in India, I think Kotora Sensei also mentioned, you get an interim relief and then you sit on the interim relief as long as you potentially can. And that has been, nobody teaches you this at law school, but this is something you just sort of pick up as you go along. The other way is if you have a bad case, you straddle the other side with litigation fatigue or arbitration fatigue. And unfortunately, the ad hoc system in India allows for that and has allowed for that in the past. But there is a sea change which is happening. You could see it even in ad hoc, but you see it because the institutions such as the MCIA do such a good job that the users who actually use them are the ones who actually go on and say, I don't want to go back to ad hoc arbitration after that. And the reason is, again, one is choosing the right institute. is choosing the right kind of contracts which deserve arbitration in the very first place. And, I do a lot of arbitrations for Japanese subsidiaries in India, and a lot of time that there are legacy contracts which are just been going on for a few years, which have never been revisited. Kutora Sensei mentioned that revisiting the arbitration clause every month. Those clauses have perhaps not been, decades have gone by and nobody has questioned them. And therefore it is important that it must come that that to relook at arbitration, relook at what are the new ways of actually arbitrating and getting your dispute resolved in India are very important. The last I would mention is also where is, even if you're a purely domestic, you're a subsidiary of a Japanese corporation in India and you have vendor disputes, the choice of seat even within India can matter, because there are courts which are more arbitration friendly, which are more commercial than others, and choosing that is a very important aspect. Last but not the least, I just want to make the point because sometimes it gets confused, and I'm perhaps speaking for Niti here, that just because it is Mumbai, it's Mumbai Center for International Arbitration, doesn't mean that it is in Mumbai only, and they are all over. You can arbitrate anywhere in India. So those are very key considerations. But to the point that you make, yes, fully agree. Thank you.
Thank you. So let's move on to the next. We have many topics to cover. So another critical point you should have in mind is whether the arbitration awards can be effectively and speedily enforced. And over to you, Karan. Another big topic for you to start with.
I think we must recognize where, as far as enforcement in India is concerned, whether you're enforcing a decree by a court or you're enforcing by arbitration, it is going to take time. And courts are trying their very best, and credit to them for doing so, to decongest the system. And India's focus on arbitration and alternative dispute resolution mechanisms are towards that, so that you are in and out of court as quickly as possible. Especially for international commercial arbitrations, the fact that enforcement directly to courts, the high courts, helps in speeding up the system. You have more commercial judges, far more experienced judges which help in speeding and the overall speed in the system. But again, as far as enforcement is concerned, you do enforce. The problem is sometimes the assets may be in a court which unfortunately saddled with a lot of legacy cases and is not able to give the time and attention to the matter. Therefore, what we do see is in India that post enforcement, we do see a lot of negotiation. Right? Enforcement, we see a lot of negotiations where parties having secured the award in their favor, trying to speak to the party to try to negotiate and settle out at that stage, rather than spending time in Indian court. Second, as far as generally the overall arbitration enforcement stand has completely changed. Tora Sensei talked about emergency arbitration. There is a lot more that is happening. The Tata Docomo case is a case where even despite the Indian Central Bank coming in and saying that they had objections to monies to be paid out, they have very clearly said that no, the Indian courts did not allow that interference to take place. As far as withholding tax is concerned, that's another issue where Indian courts have said no, there is no question of withholding to take place. Generally, courts have been pro-arbitration. We continue to see so, but question always remains, and I think the next panel speaks about it in some detail, is arbitrability of the disputes in the first place, and when that comes in the way of enforcement. But I will leave that for the second panel.
Thank you. Thank you. Daniel Sensei, I think you look at arbitration space globally. Do you have any comments on the enforcement situation in India?
Well, I can certainly support Karan's comments about how Indian litigation can be used tactically or strategically by your counterparty. And my experience is that any India-related arbitration always has in the background or sometimes in the foreground Indian litigation. And my personal view is that the most important thing is having trust in your Indian counsel. So I'm going to come to you, Karan, next time, because I think it's really critical. It's a tough process, especially for an outsider, especially for a Japanese company that may not be familiar with the way things are working in India. Having that faith in your counsel and knowing all the little tricks and rules, being ready for whatever is going to be thrown at you, I think is really important. I can also say a little bit about the enforcement of emergency arbitral orders. Actually, I was one of the largest India JV disputes I did. Started out with a JCAA, emergency arbitration, brought by the Indian counterparty. It was unsuccessful for them, and then it arbitration, and it went all the way up to the Indian Supreme Court, and they were found to have kind of cast their lot with arbitration. So that was a good result from the Indian Supreme Court, actually, a pro-arbitration result that in our case was very favorable to our client. So I think positive things are happening now.
Sure. Kotora Sensei, once again on this topic.
I have no many things to add, but I'm to be honest, I'm very surprised that how the Indian court and in the Supreme Court of India are pro arbitration in recent years. In the past, 10 years ago or 15 years ago, I do remember that the Supreme Court of India had granted some unfavorable orders for the arbitral award. But in the recent 10 years, they are very pro-arbitration and they are very granted a lot of favorable orders for the arbitral enforcement of arbitral awards. So now I do believe that our Indian court is very pro-arbitration, and we can rely on the arbitral award to enforce it in India.
Sorry, may I just say one other thing?
Sure.
One other thing that came up for me in that case, which reinforced for me that India is moving in a really pro-arbitration direction, is I found that Indian law is quite a bit more favorable to bringing claims against non-signatories under doctrines like the group of companies doctrine or other related legal theories. I think quite differently from other common law tradition jurisdictions. That was quite interesting to see. So when you have cases with kind of complex contractual relationships, you have many different contracts and parties that are not necessarily parties to the contract, nonetheless participating in the transaction. My experience is that India can be pro-arbitration even in that scenario.
Thank you. One of my experience in enforcement of award is, again, it took quite a lot of time. While the jurisprudence is quite pro-arbitration, but Indian counterparty tends to fight in court. So a Japanese party has to bear in mind that while it might, at the end of the day, will get a favorable result, but you might have to face lengthy litigation, and you need to work closely with the local counsel. Sure.
And I think what we're seeing, this cultural change comes from. I remember starting off my career as in the office of the Chief Justice of India, and he had the arbitration roster. It was very clear from the three judges who used to sit there that they were not willing to let go of their jurisdiction. They wanted to interfere. It was the culture there. Now the culture is actually, how do I get this matter off my docket as much as possible? So that is, and it has effect as far as when we're talking about if you had in a contract a choice, you had exclusive jurisdiction given to a court outside of India. Indian courts will perhaps still interfere in that matter. But if you had an arbitration agreement, the courts will likely to send you back to arbitration. And that's the distinction that has been drawn in the minds of Indian judges. And those parties who do tend to use every trick possible have been in the past been saddled with cost as well, which is also unusual in the Indian context.
Thank you. Next topic. This is also a very interesting topic, and Daniel is the expert on this, so he'll be explaining. But I think that I believe that the Japanese party has been seen as the inactive participant for the investment arbitration, but I think it's quite different in terms of India, Japan, SEPA. So Daniel, could you please explain and tell us?
Sure. So most of the panel, we've been talking about counterparty risk and how you mitigate counterparty risk and deal with counterparty risk in a transaction in India. And of course, I think that's important. That's probably the most important area to look at when you're investing in India. You want to think about that counterparty risk and take steps to manage it. But it's important also to keep in mind that there are other sources of risk when you invest anywhere in the world, and that's true in India too. There is country risk. There's the possibility of a misunderstanding or a disagreement between yourself, your company, and India itself, or an organ of India, a state of India. And the question then arises, how do you manage that type of risk? What do you do? And to an extent, you can manage it contractually. If you're in a contractual arrangement with a state-owned entity, for example, of course you can arrange your contractual relationship to manage that risk. But some risks fall outside of what you can realistically manage contractually. And luckily for Japanese investors, there exists a really good, solid treaty that provides an additional slate of kind of backstop protections against the most serious kinds of unpleasantness that can sometimes arise when you're investing in a foreign country. That's the SEPA. That's what Suzuki Sensei mentioned. And SEPA stands for Comprehensive Economic Partnership Agreement. It is more than just an investment treaty. SEPA is a broad trade agreement with lots of different components, lots of really interesting stuff in it. Most of it very unfamiliar to me, and I don't propose to talk about it. But it does have a really nice investor protection chapter. It's chapter 8, providing a full slate of kind of the usual menu of protections that you would see in a solid kind of old school investment treaty, bilateral investment treaty. That's a bit unusual for Japanese investors as opposed to other investors. India actually, in recent years, in the past decade or so, made some moves to extricate itself from bilateral investment treaties. Many countries from around the world, their investors are no longer protected under any treaty, or they have to structure through a particular jurisdiction to get that protection. Japanese investors directly investing into India are protected under the SEPA, which is really nice. So what sorts of risks does the SEPA protect Japanese investors against? Mainly, there are 3 big protections in SEPA. The first is what we call fair and equitable treatment. And what does that mean? That's kind of broad. Fair and equitable treatment is a standard that shows up in a lot of investment treaties. It's been interpreted extensively in jurisprudence under a variety of treaties. And the bottom line is this: it protects against changes to the investment environment brought about by the host state that go against an investor's legitimate expectations when investing. So if an investor legitimately expects that things will be a certain way, the state can't just radically change the situation and change the kind of conditions on which the investor came into the country in the first place. So to give an example, one of the most common types of investment treaty cases in recent years, particularly in the last 10 years or so, have been claims against Spain, of all places, for changes that Spain made to a subsidy regime. I can see Jack smiling back there. He's got one of these cases. Spain offered renewable energy incentives and subsidies to investors, both domestic and foreign, and a ton of foreign investors, including some Japanese investors, invested in Spain on the premise that they would be able to take advantage of these subsidies. And then a few years later, Spain decided it had enough of this and no longer wanted to offer those subsidies, and even tried to claw back some of the subsidies that it had paid out. Predictably, because there's a treaty in place, in this case, many of the claims were brought under a treaty called the Energy Charter Treaty. Japan is also a party to. Investors brought claims saying that their legitimate expectations had been upended by Spain's reversal on this critical policy that had been the reason in the first place for investors to come to Spain. So that's one type of case. I think a more classical type of case would be simple, expecting that a particular license would be granted, and then it turns out the license is not granted for an unfair reason, and the kind of basis of your investment has been upended. So that's what fair and equitable treatment protects you against. There's also protection against expropriation without compensation. So it's still okay, it's still allowed for an expropriation to happen. It's not the case that the state can't come and take your investment, but they have to pay. They have to pay fair value if that's going to happen. And that's an important protection because, yep, sometimes states do need to expropriate for various reasons, sometimes perfectly legitimate reasons. And the important thing is that you can at least be made whole as an investor in that scenario. And then finally, really importantly, there is an observation of obligations clause, sometimes also called an umbrella clause. And what that means is that if the state enters into an agreement, agrees to undertake certain obligations with respect to the investor or the investment, the state must observe the obligations that it's taken on. And that's important because actually one of the only public case that I'm aware of under the SEPA, a Japanese investor against India, primarily was on the basis of this observation of obligations clause. There was an agreement between the investor and a state government about tax incentives. Certain tax incentives were offered, and then there was a disagreement about whether they should be paid, and ultimately that led to a claim being filed under the SEPA. And the really good news is that it didn't even go all the way. Once the claim was filed, litigation, and ultimately there was a settlement that I think left everyone relatively happy. So that was a nice outcome in terms of what can be achieved under the SEPA. Investor was happy, and I hope India was also happy. That's the basic lay of the land with SEPA. And since we're talking about arbitration, I should mention specifically SEPA allows for arbitration of these. If you have an investment claim against India, if you feel that the protections that are being offered to you under SEPA are not being respected, then you have, as an investor, the right to bring India to arbitration to have the decision settled. Now, India is not a party to the ICSID convention, so you can't get access to ICSID arbitration. You may be familiar with ICSID arbitration, but you can still get access to vanilla New York Convention arbitration, which is perfectly good, very good for resolving investor-state disputes. Done plenty of those, and yeah, your award will be enforceable just like a New York Convention award. So it's a really great way to resolve your disputes.
Thank you. このトピックはちょっと若干初め2つにお話文脈が異なるんですけれども、インドと日本の間には包括投資協定というセパと呼ばれるものがありまして、そこには非常にインベスターにとって投資の保護に手厚い条項が今も入っております。でインドはですね、この投資家保護の条項をかなり他の国とは撤回をしていってですね、改定をしているんですけれども、日本に関しましては、外交上の関係が深いということで、いまだに非常に手厚い投資保護協定が入っています。で実際にもですね、ダニエル先生が今話してくださった通り、日系企業においても州政府との税制インセンティブが支払わなかったという事案において、そちらは最終的に和解していますけれども、ほぼ全面勝訴したという事案がありますのと、あともう一件、日系企業さんで、それは税法のですね、事後改定、訴求的税法の不利益改定があった事案においても、そ ちらも公表されている限りではですね、日系企業の主張が、認められる形で和解に至ったというようなものがあります。この協定においてもですね、日系企業の投資は他の国に比べても手厚く保護されているということが言えるかと思います。Thank you, Daniel-sensei. I think we have about 5 minutes left, so shall we take some questions from the floor? Any questions? Okay. I guess we did a good job. One question, please.
I'll throw one out there. You were talking about how quickly things are developing in India. Is there something on the horizon that you see as sort of the next change or the next development? What can we expect in the next year or so?
Well, I think we're running very close to a general election in India, and therefore for the next year or so, I think we're not going to expect much to happen until the new government comes back or a new government settles into India, into Delhi. And once you see that, you will see a lot more, depending on what mandate they have, you will see a lot more of the reforms to continue. I think irrespective of political lines, all are aligned in terms of that the growth story of India, the time of India has come and the growth story must continue, and whatever should be done to enable it. Just to give you an example of this, Daniel mentioned about, I was doing a matter in High Court in one of the states in India. That High Court had allowed Indian government to change or almost discount the PPA rate of renewable energy by 50%. And when this matter went to the division bench in the Chief Justice Court of that High Court, when we were arguing the matter, we'd also made the government of India, the union government, a party. The union government actually came up and said, perhaps learning from Spain, to say that if this decision is not reversed, we will have investors treaty arbitration against us. So it was a clear understanding of what the rules of the game are, what has to be done, and what are the obligations that a country owes to investors coming into India.
Can we also expect some, Supreme Court decisions to be made?
Actually, we've had a decision of the Supreme Court which said that arbitration agreements which are not stamped cannot be enforced. But while our panel was going on, I saw my phone buzzing that actually that has been referred by the Indian Supreme Court to a larger bench and has been questioned. So we might get that.
Okay. Also, we might have a case whether the interim order needed outside in vacamino
we
force.
could very well.
It's still pending.
It's still pending. Yeah. Indeed, all of those on group. We have the decision which is revisiting chloro is also pending. So much. There is going to be a lot more arbitration alerts coming your way for sure.
Okay. One more.
Thank you very much for excellent presentation, quite informative and insightful, and was quite helpful to my practice. So I think Kotora Sensei has explained to us, and everyone also explained to us, and also, you just mentioned that Supreme Court might change about the enforceability of emergency arbitrators award a decision outside India, enforceability of emergency arbitrators decision outside India. What's the rationale behind the Supreme Court treating two, situation differently? Means, emergency arbitrators seated outside of India and seated within India. Why enforceability has been treated differently by the Supreme Court in the past? And I understand this issue might become moot, within a month or so.
Kalan could be a good person to answer it, but I'm very surprised that my explanation will be maybe outdated soon.
Well, we do hope it is outdated very soon. But I think where the distinction is coming from is where in our law does not recognize the concept as such in the statutory framework of emergency arbitration awards. And so therefore, to that extent, that is where this distinction has come in. So where in this case, because it was an Indian seated arbitration, it made its way into an understanding that the parties had, because the SIAC rules allowed for emergency arbitration, the parties had consented to it. And it was the Supreme Court trying to innovate its way in and trying to recognize emergency award.
Yeah, it just occurred to me, it might be thanks to SIC rules, which treat maybe Singapore Arbitration Act, which treats the emergency arbitrator decision as an award. So it might be easier for the Supreme Court in India to enforce. But that doesn't make a difference, because SIAC in India also, emergency arbitrator decision under the rules of SIAC seated in India was not enforced. So even if it was an award, at the SIC, I think someone may correct me if I'm wrong, but
under Section 17, it was considered to be an order.
I see.
I think the answer is just to Karan's point, is just that because the current legislature doesn't provide for enforcement of any type of emergency decisions in India, what the Supreme Court did in that case is create, but they can only ever create a principle that is relevant to their situation. They can't declare a law that's wider than the case before them. So because the case before them was a domestic seated decision, I don't think it had to do with the recognition of that decision under any statute. It was just that that was their remit to the extent they could create it. And now it's for the legislature sort of flipping it back to the body that then recognizes that. And as you say, usually perhaps more widely.
I think I'll just add that we had an experience as well where there was an MCIA emergency order which was passed, and that was challenged by one of the parties, not in the Supreme Court, but one of the high courts in Gujarat. And the court specifically, actually, in its order rejecting the application, said that it's an emergency arbitrator under the MCI rules. The MCI rules provide for an emergency arbitrator. Party autonomy prevails, and we see no reason why to interfere with an emergency award or an order. Right? So I think it's just that though the legislation, as Sheila and Karan have mentioned, may not support it, but I think courts very well recognize that if parties have opted for an institution, the institution rules provide for it, then they will see no reason to interfere with it. I think the decision may not have been very different anywhere else as well.
Unless your matter never gets listed.
Yeah.
So thank you very much. And over to panel 2. I think they are all warmed up now. Thank you very much.
Thank you very much for the proactive discussion. Next, we will move on to the session 2, Managing India-Japan Disputes. The panelists for the session 2 may kindly come up the stage. 続きまして、セッション2、日印紛争管理に移りたいと思います。セッション2の登壇者の皆様、パネリストの皆様、壇上へお越しくださいませ。In this session 2, I would like to request Mr. John Reinberg to moderate this session.
Thank you and good afternoon, everyone. My name is John Reinberg, and I'm a counsel in Allen & Overy's APAC dispute resolution team based in Tokyo, and I'm delighted to be moderating this second panel session on managing India-Japan disputes. We have a great diverse panel for this session, bringing together a range of perspectives and experience covering Japanese, Indian, and international disputes. I'll start out by introducing the panel members. Immediately to my left, Yoshimi Ohara is a partner at Nagashima Ono and Tsumatsu in Tokyo, focusing on dispute settlement. She serves as counsel as well as arbitrator at various seats under the auspices of popular international arbitration institutions. She is a former vice president of the LCIA court and the ICC court. To her left is David MacArthur, who is the co-head of the international arbitration practice of Anderson Mori, based here in Tokyo, and he oversees the firm's global case portfolio. He has dedicated his practice to arbitration for nearly 2 decades and acts as both counsel and arbitrator. Rahul Narayan is a partner and head of disputes at Chandiok & Mahajan, a full-service law firm in India with offices in New Delhi, Mumbai, Bangalore, and Hyderabad. Rahul is qualified to practice in India and in England and Wales as a solicitor. He is also qualified as an advocate on record in the Supreme Court of India, and he has been appointed as an arbitrator by the Delhi High Court in a number of disputes. And then finally, last but not least, my colleague Sheila Ahuja is a partner in Allen & Overy's Global International Arbitration Group, the head of the Singapore International Arbitration Practice, and co-head of the firm's India Group. She's advised on a wide range of arbitration matters, both commercial arbitrations and investor-state arbitrations, as well as arbitration-related court matters. So to start with, we thought it would be interesting to get a download on recent developments in Indian arbitration law. So my first question is for Rahul. And Rahul, could you give us an overview of recent developments and how these developments will influence the confidence that parties, and particularly Japanese parties, have when agreeing to arbitration in India?
Thanks very much. Thanks very much, John. Before I start, let me plug something which we tagged away all the way from India. We actually worked on these 2 documents. One is an arbitration primer, and one is arbitration law update with the latest developments which has taken place in this year, 2023. I wish we had thought of Niti's plan about doing an ESG version and not having to lug all of this around for halfway across the world. But I do hope that you find it useful, and it's an introduction which is of some help to the people over here. I think in India, arbitration faces two different impulses, and most of our developments take place on one end of the scale or the other. At one end is, of course, party autonomy and the fact that arbitrators should be allowed to do what they want, and the fact that court interference should be minimal. On the other hand, we have the traditional view, which is based on Indian judicial review, that courts should interfere whenever they see whenever there is injustice. So somewhere between these 2 impulses lies the vast majority of Indian case law. What's been happening, at least in the last 10 years, has been that courts are progressively reducing the grounds upon which they interfere in court cases, and largely arbitration is becoming more and more litigation free. As the earlier panel did observe, many times in India, dispute resolution is kind of a long process, and arbitration and litigation are both parts of strategy in order to arrive at perhaps what might eventually be a negotiated settlement. So these are all opening gambits sometimes, which one has to consider. But even otherwise, in terms of arbitration law, the amount of interference of the court has been reduced both because of the legislation. There have been some dramatic changes in our law in 2015 and 2019, and there's a new massive law change which is perhaps due now. There's been a new commission which has been set up for looking at arbitration law in India as a whole. And well, the report isn't out in public yet, but we anticipate it may change things quite dramatically. In terms of, in fact, I could talk about developments in arbitration law in 3 ways. One is in terms of what happens before the arbitrator is appointed. In terms of how to appoint an arbitrator, again, the courts have decided to reduce the kind of inquiry which they used to do earlier. But one of the biggest inquiries which remains is whether the dispute is arbitrable or not. In Indian law, many things are not arbitrable. Of course, I mean, in no country is criminal law arbitrable. But we also have, for example, cases of oppression and mismanagement of companies which cannot be arbitrated. This makes it a kind of a big issue for many international clients as well. And this, to my mind, this seems to be an area of increasing judicial concern as well. So when courts are asked to appoint arbitrators, or they refer them to arbitral institutions to appoint, The inquiry they're supposed to conduct is whether there exists an arbitration clause or not. That is a comprehensive inquiry, and a preliminary inquiry into whether the dispute is arbitrable or not. And as you can imagine, there are commercial disputes aren't neatly falling into one category or the other. So there is still a fair bit of judicial involvement in this. Now, again, related to the group companies doctrine, there's a recent Supreme Court decision which says that when an arbitrator is being appointed, the court has to see very carefully whether that particular party is part of the arbitration agreement or not. And sometimes it's actually a question of fact, because there are group companies, and whether there is a single identity for that group company or whether there's an assignment involves some kind of inquiry. So there is still some scope of judicial involvement in this. But otherwise, generally, if it's a clean arbitration agreement, the court is not going to get into issues of jurisdiction and will allow arbitrators to look at their own thing. In the Indian law, there is again, this goes on to how arbitration stretch on forever, and how there is a legislative response to this. We have a timeline which has been imposed in the Indian Arbitration Act for domestic arbitrations, and also the same principles which are applicable for international arbitrations. Now, a domestic arbitration has to conclude within 1 year of pleadings being completed, and they apply the same principles for international arbitration, although, I mean, of course, the section itself doesn't directly apply. This does imply that, one, of course, like I said earlier, arbitrators are now looking to their own challenges and they're deciding them fairly rapidly. And in terms of arbitration procedure, there is increasing realization that things ought to be quicker. But again, I mean, it's important to remember that arbitration is frequently delayed because of the practitioners and because of what the parties want. In the end, arbitration is a voluntary process. And if one of the parties wants to delay things, they will usually find some way or the other to do it. That said, this seems to be a problem which is rapidly coming to an end because of this time restraint. Again, I mean, I don't know what the new if there is going to be a dramatic change to this, but I would imagine they would make the procedure a little better, a little easier, so as to again enable arbitration. The government is very keen, and so is the Indian industry, to promote Indian arbitration. In terms of enforcement of Indian awards, again, this was Karan's example of what things were like in 2004 and 5. Judges were keen to interfere, and they interfered in all kinds of things. They had a broad understanding of what is meant by public policy, which was a ground to interfere with arbitration awards. They had a broad understanding of patent illegality. But all of these grounds have been whittled down, both by court processes and by changes in the law. Now the grounds for challenge of an arbitration award are fewer than they've ever been in the past, and for the most in the most cases, the courts don't actually interfere as such. So this is certainly an area where the legislative and judicial developments have been quite positive. Now I think the fights are about other things, like I said, about arbitrability, but to a large extent, enforcement of awards has become much easier. Now I remember when I first began my practice about nearly 20 years ago, there was a big industrial house in India which had an award against them, an international award, which they were trying to enforce. They struggled in India for 2 or 3 years to try to enforce it. And then they found out that this industrial house was opening a new company in England. So they immediately filed in England an enforcement a mechanism to enforce the award. And literally the next day, the party settled. Now, that of course, was a kind of, again, a tactical thing. But I think increasingly now it's much easier to enforce international awards in India as well. Of course, if they're New York Convention countries, perhaps even Geneva Convention countries, it's much easier to enforce awards. In terms of, again, going back to what I said about impulses, one impulse, again, towards greater judicial role has been that a recent judgment which says that Indian agreements, in order for arbitration to take place, should be stamped. And if they are not stamped, the court won't appoint an arbitrator. Now, of course, I mean, there's a procedure under the stamp laws of our country, like there is a procedure for stamp laws of every other country, that you can remedy this, but this, of course, delays things a great deal. But now, as Karan just said, literally about half an hour back, this judgment of 5 judges has been referred to 7 judges in the Supreme Court. So once that happens, things will change again. Again, there's a big decision which is pending on group companies, which could be out any time, I think, before October, which decides on what the role of the court is in determining whether an arbitration clause binds group companies or not. I think that's pretty much our summary of latest developments in arbitration. No, and I would urge you all to please take a look at these documents we put outside for you. Thank you.
Thanks, Rahul. Another major change that we've seen recently is the new set of practicing rules for foreign lawyers, which has been introduced by the Bar Council of India. I wonder, Sheila, could you explain what these new rules mean for international arbitration lawyers acting on India-related disputes?
Sure, thanks, John, and thank you everyone for being here today. Just to talk about the history a little bit of Indian lawyers or in the Indian market opening up to foreign lawyers. In 2011, I was a few years qualified with Allen & Overy, and I spent some time at what was a then best friend of Allen & Overy's law firm, Trilegal in Mumbai. And they sent me because they said that we soon think that India will liberalize its market for foreign lawyers. And so, Allen & Overy will be allowed into India. So you go there now and soon, we'll open up. And that was 2011. And then I came back and then they stopped being best friends. I don't think it was my fault, but I'm not sure. But after that, we saw many rounds of, I think, optimistic speculation around whether or not there will be liberalization. And of course, this is something which, as some of us as foreign lawyers who have been operating in the Indian market for so many years, it's good news. I think for a lot of Indian lawyers who have been doing so much international work, there was a lot of optimism around it. And then life sort of carried on and there was lots of chatter around it. And then the United Kingdom and India entered into free trade agreement negotiations, which have been close to ending, I think, and close to coming to fruition. And somewhere in the middle of that, they released a circular, the Bar Council of India, saying, okay, now there's an opportunity for foreign lawyers to get a license on the ground in India. And this was completely groundbreaking. It was very difficult to go into any meeting and talk about anything else. And I should say that it was only 10 days later that there was an announcement that Allen & Overy is about to merge with Sherman & Sterling. But the only thing that people ask me about is, are we going to open an office in India? No one really focused on the merger. So we had to try and say, also, we are merging with the US law firm. So it's a really, really big topic. And there's a lot of scrutiny around what that regulation means. But I think the proof of the pudding is always in the eating, and it comes down to, has there been a clear structure around how foreign lawyers can operate? And the answer to that is not yet. And that's because between the Bar Council of India and the Law Society in the UK, they are still discussing the granular details of how this scheme will work. The sort of linchpin of it is reciprocity. So what India is looking for is a reciprocal arrangement where Indian lawyers get recognized in foreign jurisdictions and in the same way will recognize foreign lawyers into India. But at the moment, what we understand is that you can have a scheme where you can operate under a license, but not practice Indian law or do India-related disputes or litigation on the ground. Now, for some operations, this is obviously something which they're very interested in pursuing and are pursuing at the moment. But I think it's probably fair to say that for the vast majority of the community, both in India and outside India, it remains to be seen exactly how this can really operate in practice and exactly how both foreign law firms will be able to set up in India and how Indian law firms will sort of synchronize with foreign law firms in how they operate. So I'm afraid all of that leads to a short answer, which is it's just not clear yet.
I might open up the floor now to Yoshimi and David, if you have any questions or comments.
Well, thank you very much, Rahul, for comprehensive explanation of the development or evolution of court and legislation in relation to arbitration. It is, I think, the session one panelists also explained to us the positive side of the development of arbitration court practice as well as, legislation relating to arbitration. But perhaps, when we go to the reality, we still, face, so many challenges, particularly from the Japanese, companies' perspective. Maybe, from Indian companies' perspectives, situation has been improved dramatically. But from Japanese companies' perspective, I have to say, India is not an easy place to invest, precisely because of quite litigious, culture. Hope, we'll get some answer or hint as to how to deal with those, litigious culture in India during this session. Thank you.
Yoshimi, are you suggesting that a litigious culture is a problem? As an American, I take offense. I think I very much agree with that, and I think a lot of what we talk about here is, in a sense, a clash of cultures in the legal space, right? What are the norms in one country and another country? And coming from, I spent some number of years in Korea doing international arbitration before coming to Japan a few years ago, or coming back to Japan a few years ago. And I really do find, even between these two countries, which are in some ways have so much more similarity to them than a lot of other countries, if you put them up side by side throughout Asia or elsewhere in the world. And yet, when I talk to my Korean clients, that there is much more of an aggressive, litigious mentality that's, okay, let's go, let's fight, let's take it to the end. And the Japanese parties are much more reserved, cautious, want to preserve the relationship, looking forward to the future, and don't want to create too much disruption. It's a difference in sensibility, and I think it really matters. So one of the things that I'm very encouraged by is the dynamic rate at which India is changing. And I think that Japanese parties are in India to stay. They're not going in. I mean, I think that, as mentioned earlier, the rate of investment and business activity of Japanese parties in India is only going to increase. So it's really important that we resolve some of the issues by court or legislation. It's also important that the parties respectively find ways to grapple with the issues that remain unresolved. So,
the next question is really for the whole panel, and I'd be interested in all of your thoughts on this. What are you seeing in terms of choice of dispute resolution forum where you have contracts between Japanese and Indian parties? A number of years ago, we had the Tata Docomo dispute, which was obviously a London-seated arbitration, LCIA rules. Is London still a popular choice, or is Singapore the default option these days, or are we increasingly seeing Indian-seated disputes?
I would just jump in and add, from my perspective and my awareness, for Japanese parties, I think it's something like 80% of deals would have SIAC arbitration in Singapore, and the other 20% are going to be other, maybe in India or some other variation. But I don't know if others have a different perspective, but that's been, I guess, what I've seen.
If I may, I echo David's comments. SIAC arbitration, both as an arbitrator, both as counsel, SIAC arbitration seated in Singapore is the most popular, choice of dispute settlement. But I'm happily, introduce my recent experience. MCIA was chosen as institution when parties agreed to arbitrate in India in arbitration agreement. So we may see MCIA arbitration more, which involve Japanese parties.
If I can just add to that, and then maybe Rahul, you can comment on that. I think from my perspective, maybe just sort of starting with, because I live in Singapore, obviously we'll always say Singapore is the right choice of seat. I used to say Hong Kong, and now I moved to Singapore 5 years ago. So for the last 5 years, my answer has changed. But actually, in reality, I think to John's question about a shift from London to Asia, that is real. And people are looking at the rise of Asia, and that Asia has risen. And unless there's a particular need, which sometimes there might be, but unless there is a particular need, I'm not sure going further west has any meaningful purpose that you can't serve just sorting yourselves out here in this region. And then the second point is when you're looking at here in this region, actually parties are getting more sophisticated, and that's a good thing, right? I mean, in the earlier days of my career, particularly before the global financial crisis in 2008, nobody was talking to us until there was a proper dispute. They didn't really ever want to see or hear from us. If we said we are arbitration lawyers, it's the end of the conversation. And even our colleagues would never want to come to us, and they'd call us and say, we're signing a deal, I'm going to send you the dispute clause, but don't change a thing. And we're signing in 1 hour. But actually, I think the GFC really changed that, and waves of disputes that came around really changed that. And now I've had direct negotiations with the council on the other side, just on the dispute forum, which actually suggests that parties are getting more sophisticated, our colleagues are getting more sophisticated, but also people are thinking about this choice. That also means that sometimes you don't have the same flexibility and leverage that we used to say, you know, I think I'm going to pick this default and that's it. There won't be any discussion. And I think the final point is that in that discussion, it's quite easy. And I think the mind sort of tends to match, you know, the HCAT with Hong Kong, SIAC with Singapore, and the point that was made earlier, MCI doesn't necessarily just mean Mumbai. And I think that point is wider than even India, which is that we often now look at and encourage actually a separate discussion around choice of seat and choice of institution. And sometimes the best negotiated outcome is where you get a seat that you're happy with in terms of the court system. So you're not looking at the institution at that stage. Then you look at an institution that will help you with the proceeding. And that choice of institution may depend on whether you need a party or an institution that understands the culture of the parties better. And that's why I think when you are looking at Japan, India, where culture plays such an important part in the dispute scenario, actually having, say, a foreign seat or even a domestic seat, but the choice of seat should actually be a separate discussion, in my view, to the choice of institution. And I have seen a number of clauses where it's seated perhaps elsewhere and then MCIA. Of course, you also have a growing set of facts where you have a domestic seated MCIA proceeding of very large Indian corporates fighting each other, which means that at the very highest level in that jurisdiction, there is comfort. And that's how every institution begins, right? Where it goes international and the comfort starts internally and then spreads. But I guess as I say, my view is that the choice is a lot wider and should be made very carefully and separately.
Thank you. The pleasure of being the last speaker is that you can tend to agree with everybody around you. But I think the truth is that when it comes to international arbitrations, there's also a great deal of familiarity now, both among the business side of things, but also the lawyers and judges with Singapore. Singapore has been aggressively marketing itself, which is, I think, to the benefit of them and to everybody else. And now there is so much familiarity between the two legal systems that it almost has become easy enough to recommend them. As the last panel did observe that many times when you have parties of two different countries, you prefer a third country as a seat of arbitration. To that extent, of course, Singapore has become a very, very popular choice. But that said, there's still some legacy arbitration which go to London. It's not that London has stopped getting arbitration work at all. And funnily enough, there is still some stuff which still goes to Hong Kong. I think one of the reasons for maybe the lessening of the work of Hong Kong of late seems to have been perhaps the relations between India and China aren't as good as they should be, and there are fears about what Hong Kong might entail. But generally, as a court, I think the Hong Kong arbitration is very solid, and particularly their commercial judges are second to none in the world. I think that there seems to be also some interest, but it's basically academic yet, in Dubai as a center of arbitration. But then again, I mean, the many factors you would have to consider in this would be, for example, judicial control of the seat and how that would work in different ways. So I think for the time being, yes, for international arbitrations, we tend to prefer Singapore, with London still coming a close second. I think in terms of for domestic arbitration, many people now prefer institutional arbitration over ad hoc, and that also is improving. I mean, I think I did some institutional arbitrations in India about 10 years back, which was, I think there was no real difference between an ad hoc arbitration and the institution. But now with process hearings and with fairly strict timelines and with rules being enforced, institutional arbitration in India is much better than what it used to be. And I think that in many cases, it might be prudent to have an Indian seat, particularly if, for example, there is a foreign investment inside India, a Japanese company, for example. If this for its subsidiaries, it probably does make easier. It makes more sense to have an Indian arbitration, particularly when the stakes are not particularly international. If there is a large complex transaction involving multiple jurisdictions, then perhaps you might choose something like Singapore or London. But if it's a smaller or a less complex transaction, particularly where I think it probably would be worth it to take it to India.
Yoshimi and David, you both mentioned earlier the importance of cultural differences in dispute resolution, and you mentioned this perceived litigious culture in India. Could you give us a sense of what your Japanese clients are concerned about when they enter into cross-border transactions, and particularly in India? And is there any advice that you find yourself giving Japanese clients operating in this space?
Thank you, John. This is really, in the real world, difficult question. Well, many Japanese companies ask us whether arbitration is at the end of course, parties choose arbitration as a dispute settlement proceedings, settlement mechanism, but Japanese companies are now understanding or getting aware of the difficulty in enforcing an award in India. Now, these panelists in the session 1 and panelists in session 2 all, saying that the judicial, environment and also court practice towards arbitration has been dramatically improved last 10 years. And courts are less interventionist, and Supreme Court essentially endorsed enforcement decision of the High Court. Yes, it is remarkable there are only 2 layers of court proceedings when it comes to enforcement. And High Court, so long as you choose the right court, High Court, at the end of the day, may enforce the award or issue the you call it decree, may turn the award into decree, and many times, Supreme Court just reject whatever groundless appeal to Supreme Court. But the problem is that's not the end. Again, it comes back to the cultural difference. I haven't seen Indian parties, I'm afraid to say this, I haven't seen Indian parties voluntarily comply with the award, voluntarily comply with the, Supreme Court decision, voluntarily comply with the decree. So we really have to step into the next phase, even after, well, first we get the arbitral award, and second, get the, High Court decision or Supreme Court decision to recognize the award. And third step follows, which is the attachment over the assets. Well, search the assets and then attach the assets. And we have to explain to Japanese party, this is what you need to anticipate. So, even if you prepare a nice contract, and even if you get the award favorable to you, that's not the end. If you do business in India, you have to live with this system. And if there's any, good advice has to deal with it, well, this is completely different from our culture. Very few Japanese companies, in my experience, again, my experience may be quite limited or, not comprehensive, but in my experience, most of the time Japanese parties follow the award, or even if they resist, but I haven't seen Japanese companies, even resisting the recognition or enforcement decision of the court. So this, long process of settling or enforcing the contract we have to tell the Japanese companies that's what you expect. You have to anticipate when you deal with Indian parties in doing business in India. So, but nonetheless, I advise that the contract should be spelled out clearly, because in my impression, Indian parties do not necessarily, happy to prepare quite detailed contract when you compare the contract with American parties and Indian parties. My impression is contract with Indian party is less comprehensive, and business between Japanese party, Indian parties often tend to rely on some sort of relationship. But of course, relationship is quite important in doing business in India. But even though enforceability of award is quite challenging, enforcement of the award and recovery of the recovery based on the award is quite recovery of arbitral claim is not easy. But the starting point is go back to the basic, prepare a thorough contract, and at least easier to get an award. That's the starting point. But I really love to hear your advice as to how to how to deal with this business culture, I would say, in India, and many Japanese companies are not familiar with. So if there's any tips in dealing with this, I would very much love to hear. Thank you.
Perhaps fight fire with fire. I do think Japanese parties would do well to be a little more aggressive than they often are, and a little bit earlier than they often are. I think on balance, they're often a little too conservative, a little too reluctant for their own interests, right? There are also some very wonderful qualities that come of this same mentality, and I do love Japan and all of the cultural depth that goes behind all of that, but it can be exploited, it can be taken advantage of, or you can miss opportunities. Jumping back from the kind of the enforcement side, I would add a couple of things that I think are important for advising Japanese parties in this context. And I think a lot of it comes down to, as best you can, laying the groundwork to avoid problems that might arise later, and understanding the litigious culture of India, the way that parties do operate, the way the courts do operate is, you've got to first understand reality and then figure out how you're going to grapple with it. That's the truth. So a couple of things that have already been mentioned, but I'm just going to add a point to them. And the first is the National Company Law Tribunal, which is a quasi-judicial body that in India has exclusive jurisdiction over some issues, including, as mentioned, kind of minority shareholder oppression claims. What that means is if you've got an arbitration clause, but a claim arises which arguably or is said to be or allegedly is a minority oppression claim, that would be not arbitrable. So you cannot take that to arbitration, and you must take it to the NCLT, this quasi-judicial body. Well, naturally, that can be exploited, and parties that want to make trouble and make delay can use that to bring a claim, and they call it kind of dressed up. They can dress it up as a minority oppression claim, whether it is or not. The court, this NCLT will have to decide. The courts may have to decide, the tribunal may have to decide, but in any case, delay can be introduced by that as one means. And this happens often enough that it gets discussed. There was recently a case in Singapore, Singapore Court of Appeals, Mittal v. Westbridge, which I think has been talked about some amount. But I'll just add something quickly about that. It addressed this issue. And the Singapore High Court did a couple of interesting things. The first is that they evaluated this question of arbitrability. How do you wrestle with that? How do you deal with that question? And they came down with a procedure for deciding questions of arbitrability, which is two-part. In the UK is the same, but basically they look at the law of the seat and they say, is this claim arbitrable, non-arbitrable in the seat? And then they look at the law of the arbitration agreement. And they say, is it also non-arbitrable there? And you've got to hit both of them in order to escape your arbitrability problem and go to arbitration. What that means in reality is if you're in Singapore, if you're seated in Singapore, then Singapore law will apply and govern this question of arbitrability. So you can probably get past this problem of exclusive jurisdiction for minority shareholder oppressive claims. The problem is that you have the second part in the arbitration agreement. What is the law of the arbitration agreement? And the problem there is it's often not explicitly stated. We don't do that very often. And increasingly, there's more and more talk about that you ought to say. So even though you've got a contract and there's an arbitration clause in it, and the contract says Singapore law applies to this contract, for reasons, it doesn't necessarily apply to the arbitration agreement, right? You should say in the arbitration agreement, the law of Singapore governs this arbitration agreement. And so that is the advice that I would suggest to sort of help you get past this potential problem. One of the issues that comes up with India disputes is to add that explicit language in the arbitration agreement designating the law. The second point, and I'll try to be quick about this one, because I think there was some extensive discussion by my colleague Kotoura Sensei earlier about interim relief and the fact that if you get pulled into Indian court to seek Indian relief, that can be quite extensive and belabored process. It can take a lot of time to resolve. So you kind of want to stay out of that. But of course, it's normal in most countries that if you, even though you have an arbitration agreement, if you want interim relief or emergency relief, going to the courts is an option. This is not unusual at all. The difficulty in India is that it's often used as a tactic to create delay. And part of that is because the court system just takes time. So one of the things that I think is advisable to Japanese parties going in, as my colleague earlier mentioned, is that Section 9 of the arbitration law of Arbitration Act of India, which governs emergency relief, should be excluded. It governs the court-issued emergency relief, should be excluded from within the arbitration agreement, the dispute resolution clause, exclude that so that emergency relief or interim relief would be left to the arbitration process only and not the courts. And that can help avoid, I think, two of these delay pitfalls that happen in India.
Sticking with the cultural differences theme, but this time focusing more on the procedural aspects of the arbitration. Sheila, I might put this question to you. What are some of the nuances that you see in terms of the taking of evidence between the differences between Indian and Japanese approaches to the taking of evidence?
Thank you, John. And perhaps I can just use the opportunity to make a couple of points. First of all, I think that when you are, I actually had the benefit as a team, we represented Nissan in the case that was mentioned earlier by Dan under the SEPA, the Nissan versus India treaty case under the SEPA. And I know he mentioned that everybody was really happy at the end of it, but as the law firm that was waiting for the second jurisdictional decision and also, you know, was quite enjoying the dispute. Yes, we were happy, but there was a limit to how happy we were as well, and we told Nissan that. I think that actually case represents quite a few things, and there are a number of Japanese-India disputes that we as a practice have had the benefit of doing. What I would say is taking of evidence is one of the biggest differences in a culture that is very compliant and takes very seriously their obligations, like here, versus a culture that actually understands that, you know, there are different ways of doing things and we can use, you know, opportunities to our benefit. It's actually not always the case that I've done cases between Indian parties and other cultures too. And actually, I'm often in the situation where the Indian party is the one complying. So it's all relative, is what I'd like to say. But I think that when it comes to matters like taking of evidence, is quite critical in an arbitral process when you're agreeing something up front and then actually only one side is sort of playing ball and the other isn't. And what I would say about that is that it's really important to grapple with that up front. To a point that you made, David, is just to nip it in the bud as soon as you can. One of the things that we start to do, for instance, wherever we see, you know, Indian or whatever culture, if there's any likelihood that the other party is going to be recalcitrant, then up front we will ask the tribunal to incorporate in their order what the evidential phase is going to look like. Sometimes there's actually resistance to expressly refer to the IBA rules on the taking of evidence, which is a very narrow but very, very focused and helpful form of disclosure, I would say. And there is resistance met with this. Sometimes when you have state parties, actually, even with all the procedures in place, you just get nothing back. And you get a party that does a lot of work. I've done a case for an Indian client against a non-Indian state. And, you know, we said to the Indian client, you be diligent, you follow everything. And they did. And we got nothing from the state. And we said, oh, okay, sorry, fine. Maybe this wasn't the right case for that advice. So actually, sometimes it's a question of learning who your opponents, your client and the opponents are, and then trying to characterize your procedures. One of the greatest benefits of arbitration, I think, and I don't think lawyers do it enough, if I may say so. I don't think they think about the issues enough at the first CMC. I just had a CMC last Friday, and the tribunal logged on thinking it's going to be a 5-minute meet and greet, and we said, we'd like to talk about the following 10 things, you know, and we want it put into PO1 because we want to make sure that everybody's signing up to this procedure up front. I've also had a case, it might have been the Nissan one actually, where we got the parties also to sign PO1, not just the tribunal. So I think there are many things that you can do to try and push things along and sort of narrow your framework right up front. And just if I can add to David's point, I very much agreed with this, how do you tackle or what advice do you give to a Japanese client? One of the reasons why I was put on cases for Japanese clients against Indian parties is, you know, they said, how do we deal with this? And, you know, it's knowing what will come, right? And we said, I mean, I can't tell you too much because I'll be giving away my practice. But, you know, we did spend a lot of time saying, I can tell you what they're thinking, and this is how we'll deal with it. And yes, it required the Japanese organization to say, first, they just said, no, Allen and Overy, we don't like it. So you go away and come back with something else. And then we said, can we have a chat? And, you know, we had to come here a lot and sort of talk to them and say, honestly, this is how it needs to work. We're not being disrespectful of the procedure. We're actually being protective of your rights in a way that is consistent with the bargain that you signed up for. And it does take a little bit of pushing both ways. Of course, then we also likened the discussions around the settlement of the Japan-India case, then went to the other side and said, look, we know you guys, we know how this is going to work. Don't do it. And let's kind of, so it requires a bit of nudging and shaping on both sides, I think, and proactiveness on the part of lawyers.
Could I just add to that? I've been thinking about what to say about the culture point. I think in a broader perspective, both what Indian and Japanese people have in common is, in the end, there should be a negotiated settlement. Like I said, to start with, many times Indian litigation and arbitration is all tactical. If you are able to, well, of course, first of all, you enter into an agreement only with somebody who you can trust, if that helps. The second bit of advice I'd give is, again, like everyone said here, have watertight agreements and be careful about the processes you choose in your arbitration. But in the end, there is going to be a negotiated settlement. So I think the point is that many times Indian parties feel that they are at an unequal bargaining level for straightforward negotiation. So the point is to push the other party in a direction so as to have a more favorable terrain upon which the settlement is arrived at. I think the important thing to remember is this, that when I advise a Japanese client, for example, I try to ensure that they don't have that advantage. I mean, you play a defensive game to start with to ensure that they don't score any goals. I mean, for lack of a better metaphor. But I think that is the actual thing. Remember, in the end, it is going to get settled. And many times there is a certain kind of, almost you can put it, drama involved in the litigation process or arbitration process. But like I said, in the end, what's actually happening is sort of different from what is being perceived to be. So I think a good advice from to Japanese clients is simply this, that you hang in there and you ensure that you don't suffer from procedural problems. I mean, death by 1,000 cuts, for lack of a better word. So you should ensure that doesn't happen to you. And for that, we take Sheila's advice completely into consideration. You look at how the procedure takes place in an arbitration, particularly with regard to evidence. I think the biggest difference between Indian domestic arbitrations and international arbitrations I've seen is the discovery process. In Indian parties don't necessarily have a particularly well-developed system of many parties don't even keep proper correspondences. And often they don't have a system of discovery. You file what you have and you just go ahead with that. So I think it would be prudent for a Japanese company to sort of insist on proper regulated procedures, perhaps like the IBA or something like that for taking of evidence. And in terms of interim relief, I think it's a bit of a thing, because if I had I would prefer to go to the court and take an order which is completely enforceable for particular kinds of interim relief. For example, if you're afraid that your joint venture party is siphoning away all the money, by the time you go to your arbitrator in Singapore or wherever else and you get an award, it might already be too late to enforce that. So for that, I probably would prefer to go to the courts under Section 9 and take my chances. In the end, I mean, you have to, I mean, it's difficult to prescribe a standard rule as to what would work in all circumstances. But I mean, it's something to think about. I mean, Section 9 exclusion was standard advice many years back. Now I would say that we don't always go by it. Sometimes we tell people to go to court instead.
I just want to say this is many of the things that you just said are sort of really lay a great foundation for the thing that I wanted to add at this point. And I think when you talk about litigious culture, aggressively litigious cultures, it's in some sense tactical and play acting, right? It's real in the sense, yes, you've got to grapple with whatever procedural things are happening, but it may not actually reflect what the party is really aiming for. And it may be that the aggression is looking for to just put themselves in an advantageous position to settle the matter, right? I think that Japanese parties should really be aware of that. The aggression and disruption that they may be seeing, yes, it's difficult to deal with, but in fact, it's maneuvering on some level. And I just want to briefly sort of mention a case that I had, rather sizable, Japan, India, and it was chaos. And the parties were at each other's throats, and there was absolutely no sense that this was going to ever be resolved by amicable settlement. It was just madness. And yet, it was during the COVID pandemic, and there had been a protocol for online mediation that was set up by Singapore International Mediation Center and the Japan International Mediation Center. And at some point, it got suggested that we try a mediation, and both parties agreed to it. I myself was highly skeptical as to whether this was worthwhile, but I find mediation is often useful just because you get information. We went to it, and in a matter like a 3-day mediation, and they settled in 2. It settled so quickly, and the parties, it turned out, on both sides were ready. Nothing about the atmosphere seemed to suggest that whatsoever. So I think sometimes it is just a matter of hanging in there, positioning yourself the best you can, and then maybe having a leap of faith and trying something like mediation. I don't know if others have had good experiences with mediation in this context, but if that was any signal, I think it's potentially something to look at.
Well, we do have a new mediation law, But unfortunately, that doesn't deal with recognition of international mediation settlements yet. Although India is a signatory to the Singapore mediation thing, I think they're still waiting to see if other countries ratify that. Many of our arbitration clauses usually contain a 30-day mediation period to start with. Sometimes it's, I mean, earlier the court's attitude used to be, and everybody's attitude, what is this? It's just, we'll just go there to get information. But sometimes there seems to be an actual push from both from the government and from, well, even from lawyers, at least to the extent we can, to try to see if there is some settlement to be arrived at. Because in the end, nobody wants to be in court for a long, long time, for 20 years or something, sometimes it could take. So you tend, there is some hope for mediation, but I think as we watch this space, many Indian law firms also, for example, are including us, we practice as well. So there is going to be a proper system in place to ensure that mediation takes its place among ADR. That said, I think there is something to be, I mean, at this point, I'd be a little skeptical about the mediation arbitration combined, which sometimes happen, I think happen in Japanese arbitrations, where the arbitrator acts as a mediator as well. So if there is, I don't know if that's the case just yet. In China, of course, they do that, yeah. Sometimes awards like that, aren't easily enforceable because of allegations of bias, etc. in enforcement. So I'd be a little careful of mixing that. I probably suggest that if parties were arriving at a mediated settlement, then they have a consent award, which would be much easier to enforce.
Thank you. Just to clarify, so arbitration seated in Japan, just like, arbitration seated in India or in Singapore, arbitrator cannot have double hats. So arbitrator cannot turn into mediator and mediator coming back to arbitrator unless parties clearly agree in advance in writing. Yes, it is true that, in Japanese court, judges towards the end of the court proceedings all the time check the parties, whether parties are, discussing settlement outside of court, or parties are interested in having a judge acting as a mediator towards the end of the procedure. So it happens all the time towards the end after parties essentially complete the pleadings, not in the middle of the pleadings. But that doesn't happen in Japanese arbitration seated in Japan. So please feel confident about the combination of mediation and arbitration in Japan as well. But it is true, the successful mediation between Japanese parties and Indian parties, David referred to, was widely, reported in Japan, and Japanese parties surely, appreciate mediation more. And it's encouraging to see that mediation law was enacted, and we hope to see more mediation to be used between Japanese and Indian parties.
Actually, what I meant to say was that the new combinations of mediation and arbitration which take place, where there's a kind of a unique kind of mixture, where they increasingly start with a sort of mediation. I mean, of course, as you correctly said, in all of these cases, there's usually a written consent by the parties that you can act as a mediator. I'm just saying, despite all of that, it would be if I were a lawyer on the other side, I would just say that it was completely inappropriate, and you can't contract out of bias. So I would still say that's something that would be I'd be a little wary of. But that said, I mean, again, if it's maybe it's a procedural thing, but if you get a consent award, that would be much easier to enforce rather than an international mediation settlement, for which we don't actually have a mechanism right now to enforce in our law.
I'm afraid we're running out of time. It's been a really fascinating discussion. Niti, do we have time for questions, or we have to move on to this? Yes. Why don't we take it outside? Thank you all very much for your attention, and thank you to the panelists.
Thank you very much for all the panelists. Please return to your seat. Yeah. Okay, now lastly, I would like to request Ms. Niti Sachdeva, Secretary General, Mumbai Center for International Arbitration, to give closing remarks. 最後に、ムンバイ国際仲裁センター事務局長、ニーティ・サチデーバ様より閉会挨拶をいただきます。
And you see me back here again. I'll try and be very quick. As closing remarks, we've heard two sessions which discussed a lot of things, and I probably would like to point out and comment on only 5 of them. And let me begin by talking about what Tycho spoke about, delay in arbitration proceedings, and how, I think all of us who've dealt with India at some point in time have horrid stories to talk about arbitration taking years. But I must tell you that with our 2015 amendments in the legislation, things have become much better. And also at an MCIA, what steps have we taken to make sure that the arbitration process is quick? I think I can very confidently claim that MCI rules are probably the only rules, arbitration rules around, which have a provision that the presiding arbitrator is always appointed by the MCIA. Why this tweak in the rule is really in the sense that the parties nominate the arbitrators. We usually see that there is a kind of a balance which they're trying to create, that the presiding arbitrator, who's more senior to them, maybe it gets even more difficult to have an availability of time, especially in an Indian context if you have judges. So we made a very conscious effort in our rules to say that even though the parties may have agreed to have the presiding arbitrator appointed by the two nominated, but MCI rules provide that it will be by the MCIA. We're currently administering about 80 arbitrations. We've given awards in almost about 50 arbitrations. And again, statistically, I can tell you that all our arbitrations have got over within a time period of 12 months to an 18 months time. The second thing, of course, which everybody talked about today was the change in law and what's happening and what we can anticipate, for things to change in India. Of course, we heard about a lot of Supreme Court judgments, which we are awaiting to hear. But 2 more developments that I can talk about. One is that we currently have what I think Rahul alluded to as well. We currently have the arbitration committee, which was formed to relook at the reforms. We adopted the 1996 model law. The law came in. We didn't change the law at all. We changed it in 2015, then we changed in 19, and now we're again looking at amending it to make sure that we are up to date with what's happening internationally as well. And in tune with that, MCIA was also revising its rule this year. We will open the consultation in about 2 weeks' time when we launch the India ADR Week's 3rd edition, is when we launch the draft of the MCI rules, and we'll be very glad to have your suggestions on it as well. The third that we spoke about, of course, is challenge of awards and how enforcement, of course, becomes a big issue. I'm, of course, not here to tell you that it's all hunky-dory or that our house is completely in order. It's not. But I think at least the intention seems to be of the court, of the legislature, to make sure that parties do not see themselves saddled in the courts purely for an enforcement purpose. There's a lot which needs to be done, but I can tell you again statistically, because they speak for themselves. There has been no single foreign arbitration award which has been set aside in India in the last 20 years. So we may take time to enforce things, we may take time to get you your money, but the Indian courts have been very reluctant to interfere in any of the foreign awards. The fourth point that I have, and what David spoke about, that how you need to look at your model clauses. And we had the first session talk about that probably you need to relook them at every month, which may or may not be very easy. And I do not want to take away the job of my law firm friends here. But one thing which institutions do is that you can always approach an institution to send you a model clause. They have it on their website as well, but I can tell you for MCIA, and I'm sure it's the same for JCA as well, that if you were to write to them and say that we have a contract which is broadly about this subject, is what we're looking at, could you please just suggest us some draft model clause? I would say it's good to, it's good to move away from the champagne and the midnight clause and just copy paste. Just go to an institution, ask for it if you do not want to pay the legal fees of the lawyers. But again, always consult your lawyers. Last but not the least, I think what we have to talk about is why choose MCIA or JCA, have this whole evening dedicated to it. And I think other than what we've already heard from both the panels, one thing I definitely want to point out is cost comparisons. Whether you look at the JCA rules, which I was re-looking at while I was sitting here and looking at the fee schedule, or if you compare the MCI rules fee structure, I can very confidently tell you that in comparison to SIAC or ICC, and in no ways to say that they're not good institutions, but they can come out to be quite expensive when you're trying to resolve your disputes. So I think with that, and like I said, because we have the presiding arbitrator whom we appoint, so even if you have an arbitral tribunal where you have the civil law and the common law jurisdiction both being to be taken care of, MCI can step in to appoint an arbitrator not only from India but outside as well. With that, I thank you all very much for being here with us today. We would like to continue to have this dialogue to see as to how we can help in effective dispute resolution process. I would like to thank our partners, Chandyok and Mahajan and Allen and Overy for all their support and for all our speakers who have taken out time, like I said, on a short notice to be here. And I would like you to join us for a high tea, some Indian snacks, which I hope you like, and hope to see you again very soon. Thank you very much.
Thank you very much. We will now conclude the symposium on India-Japan trade relations, risk mitigation, and dispute resolution today. Thank you very much for your participation. 以上をもちまして、本日のシンポジウム、日印貿易関係リスク軽減と紛争解決を終了とさせていただきます。本日はご参加いただきまして、誠にありがとうございました。この後、今夜この会場を出てすぐの会場で、ネットワーキングセッションを開催いたしますので、ぜひご参加くださいませ。